Alright, it looks like I'm streaming, so let me get started here. I was going over some some different, the same information, but I'm looking at it in a different way. And I've got to keep my voice down because of issues with no soundproofing. So I really should be whispering here, but I'll keep my voice down. And I'm I'm uh, I'm here to discuss the issues with how what the heck's that kid's problem? With how people are, with how courts are conducted in a way that is like a blank page, and I find that concerning. Okay, uh, and it's going to influence my approach for future court hearings because I had to go through this tough challenge um, to learn how things are conducted. There's kids just laughing. Um, so the training that I got out of Natchitoches has been useful. I mean, it has not gone to waste. Learning how dirty they can be. I mean, I guess I could have learned how dirty they can be in Williston had I decided to stay in the city court and have things decided that way by them. But because I did have the choice to jump out of that city court, I left and didn't bother. I mean, I got a strong taste of city court decisions, city court values, morals, their objectives but within the first couple of weeks of some decisions that they did have the first bite of the apple for, like for my bail and deciding on whether I can get a public defender or not. All right, two judges in Williston, two separate judges in Williston said no to a free lawyer, and they pretty much. I was even poor. I even had even much less money in Williston, and they denied me. And I filled out paperwork for that, but it was to know. It was first time I filled out the paperwork was in jail, and then the second time I actually like looked at my bank statements and I put a higher amount of earnings, and the judge used that against me. Judge Wilder used that against me, saying, "Oh, it shows here that you make even more money. That makes you even more or less qualified." But it wasn't until I got to district court with Judge Roosted, he was very quick in the first hearing to approve a free lawyer. So there's a little bit of let's say a pattern of behavior. There's a pattern of behavior with city judges denying free lawyers for the poor. That's I mean, that's not just a Louisiana thing. It's not just a Judge Owsley thing. They'll deny free lawyers if you show any money. If you have, if you have a bank account at all, and you have the minimum of $5 just to hold that bank account, they'll say you have enough. You can borrow money from friends and family. They have this attitude like that you can get it from anywhere. yeah, just to cover those costs. It's just magically appears. That's how salesmen think. Like vacuum cleaner salesmen, they'll go to trailer courts. They'll go to the poorest neighborhoods and try to sell $1,000 vacuums and just say, well, if they can smoke cigarettes, then they got enough money for a vacuum. All right, if people have the ability to find money for cigarettes, then they have the ability to find money to buy $1,000 to thousands of dollar vacuum. And this was a Filter Queen when I was learning a little bit about Filter Queen. And judges have that same salesman mentality where you can find money anywhere. So it doesn't really matter how much you show on paper, and they expect you to lie because they lie. So it's like they have this perspective that you're always going to underreport how much you have. So whatever you have, they're gonna double it, triple it in their minds. It may not be what you write on the paper, but they know that you could find money for cigarettes. You can beg, borrow, or steal. Find ways in those desperate times to get that money. Let's see. I'm gonna read some comments here just a second. When it comes to lawyers, you get what you pay for. Alright, Chevy says, hit, you're a tough cookie with a long history of breaking little... Is that a song? They use your money against you, then take it from you so you will qualify next time. Okay. Yeah, that's the thing. It's I spent a lot of money in Natchitoches now on transcripts alone. They're gonna have a nice Christmas this year, thanks to me. That's gonna be a Heinz Christmas from all the attention they've gotten, from all the money I've given them. But we go into this court cases with this like a blank page. It seems there's something about how these courts, they don't recognize precedents. They don't recognize precedents from other courts, from other cities, from other states. They don't recognize, but they mention precedents. That's a strange thing. I got this judge, the city judge, Judge Owsley, telling me that recognizing precedents is different for it's different in Louisiana compared to other states. I hear him say it's different precedents. They recognize precedents different. I'm hearing him say that, but I think he's really saying that precedents don't mean squat. That's what he's saying. Precedents don't mean nothing. Even if he gets slapped with a civil rights violation, he'll just turn around and ignore it? Is that how this works? These guys, they don't recognize other precedences, and it doesn't sound like they're going to recognize their own precedents. If they get a decision turned against them, they're not going to recognize it. And that's the attitude that the city judge has brought. And you gotta wonder if the appeals court knows that. Like, will they just question? What's the question they'll ask? Why even overrule this city judge? Why overrule Judge Owsley? Because he's not gonna follow the precedents of his own actions anyway. He's not gonna change how he rules on court cases because he doesn't have to recognize precedent. He just kind of makes it up as he goes along. And why do we even have an appeals court if they have no power over him? It's like, this is the attitude that they had in North Dakota too, that the prosecutor was arguing on the city's behalf. They were like, they get the whole bites of the apple. They get to stuff the whole apple in their mouth, and no one else gets a taste of that. All right, but that was the attitude they had, and all they had to do was go up one level to the district court with Judge Roosted. I mean, the prosecutor Taylor Olson, she made the argument that it ends the deciding factor ends in the city court, that the district court has no jurisdiction over deciding whether I get a free lawyer or not. And the district court's like, hold on, that's not true. And that's the attitude they had up there, and they have that attitude even worse in Louisiana, where I don't even have the ability to go to district court. I have to go through the whole process with the city court, them thinking they got the last bite of the whole apple. They can't. There's nothing that can overstep what they decide, no matter how egregious, how awful it is, how beyond our civil rights it is. They get the whole apple. They don't. They only and it's supposed to be just a bite, because there's levels to this this judgeship, this court system. The court system is a military structure. There's ranks, but the city judges don't recognize the ranks. At least maybe they don't want to think about these ranks. It's so rare that people go over their heads anyway. And since most people don't, they probably know the psychology of people who don't go to the higher levels of court, and they use that psychology to their advantage. What keeps people not appealing? I mean, not just psychology. There's financial. There's fear. There's a lot of factors that prevent these cases from going to the next level. So they were so confident that they could just keep me within their whole bite of the apple jurisdiction. I'm the apple. They ate me all up, and that's it. It ends. They did everything in their power to just swallow me whole in that city, and they did a pretty good job. I mean, to the point where I was actually physically, I was I hadn't I didn't present to them much of a threat, and I portrayed somebody who really is vulnerable, somebody who really would be pretty easy to swallow in one bite, and they went through with it because they saw that. But it really was a miracle to have the events occur while I was in jail to have occurred. I was unable to do anything while in jail. I sat there for hours, having to put up with other people wanting to watch certain programs on TV at high volumes and listening to various conversations about nonsense, and having very limited access to a limited computer with limited time. It was like they closed. You could write emails in this weird format that costs like 50 cents per email, and this computer was like had closing times. They would just shut it off between like I don't know, 2 p.m. to 6 p.m. or something. And in the morning it was it closed at like 10 p.m. to like 7 a.m. There were some really limited hours, and I mean these are full jails with a lot of young guys who are very proficient in the computers. So a lot of people now are more dependent on computers, which are a fairly new thing actually for jails. Yeah, the worm, and they took the whole bite. They both fish, two fish took a bite of the same worm, one on each end, and just swallowed me up as they felt. But I couldn't do anything, and they knew that. Immediately, I mean, they immediately threw me in jail, and I mean, everything, all the events that occurred while I was in jail was pretty much a miracle. There was there was a real a real like serious real set of moves that happened that overcame this being swallowed. Like I was Jonah and the whale swallowed me. And then it took like people to poke at this whale from the outside. I couldn't do anything. I was sitting in the dark inside this whale's stomach, and I couldn't do anything. Just let the time pass. I had a hope though. I mean, I had this sense of hope that I would be out before the 30 days, but that's all I had. I mean, I was getting some positive messages from Dan Boquist, from Robert Parker, the pig trader Robert Parker. I was getting some hopeful messages, and from some other people too, who just wanted to help out. And they had the help from the outside, not even in the city, not just outside the jail. We're talking out in just maybe they're all within the United States, I'm sure. My biggest help comes from at least inside the United States, not so much outside the country. Most people don't understand how the system works outside the U.S. But they put things together. They line things up. I mean, the two biggest let's say two biggest circumstances, events, two biggest choices, the two biggest events, the two biggest, let's see, two biggest, like certain there's a word for it, I'm sure. Just thinking of like circumstance. No, Maybe I need a thesaurus here. Let's see. Two biggest. Let's see. Call it stances. The two biggest conditions. The two biggest conditions. No, the two biggest things. The two biggest occurrences. Okay, there it is. The two biggest occurrences happened with getting a lawyer, and then also getting a bond, an appeals bond. Those are the two biggest occurrences that I mean I couldn't do myself. I wasn't able to line up a lawyer, and I wasn't able to get that appeals bond. I was told to get the appeals bond set before I go to jail. And I was kind of confident I wasn't going to go to jail, so I didn't really do that work. Other people did that work. And that's the thing, the judge, the prosecutor, they knew I was a bit lazy. They knew I was coming in to Louisiana with no knowledge about how things work. So how things came about, how things turned out was pretty extraordinary. It was things that happened that clearly I had no hand in. I had no ability to do what was done while in jail. While these things happened, I was in jail. There was nothing. I mean, I couldn't pretend to convince. I couldn't convince anybody that I lined up a lawyer and that I got that bond, that $1,500 bond. So these are extraordinary events. In fact, even the whole trial, to have made it last 6 hours was definitely beyond my ability. To have asked so many questions that were so relevant and so pertinent, so useful and helpful, I wasn't able to do that myself. I mean, this is the work of just a few guys, unpaid, whatever you call them, interns. I guess they're kind of like an intern, or they're professionals. The volunteer professionals who stepped up to make certain events happen. If I did not get any help, then this would have been me having served 30 days and then paid the fine, and then that was it. I guess I would have been clear. I would have been on let's say I would have had my account, my debt to the city would have been paid off with the 30 days in jail and $411. I would have had. I think I would have paid that. I may still have to. I don't know. But the events that occurred while I was in jail are what has helped lead up to this. And now, well, we're in this waiting phase for the decision from the appeals court. Maybe they made a decision. Maybe they have a decision already to go here, and I just haven't checked my email in the past 5 minutes. Yeah, they want some time. So these courts, they have no precedence, and they don't recognize precedence. What's the deal with that? Why don't you recognize precedent? If you don't recognize precedent, all right, if precedent's done a little bit different, you're saying that it's biased, all right, because I got the judge saying on one hand that he has to follow the Supreme Court about recording in the courtrooms. That's precedent. Maybe he doesn't understand the word. All right, let's see if we can define that. Because precedent is very selectively defined by this judge, by city judges. I would say city judges because they're working with the same game. They're working with the same game book. The precedence, the condition of being considered more important than someone or something else. Priority in importance. Okay, yeah, precedent. It's more important than you, judge. The precedent of previous court cases is more important than you. But you say that how you recognize that is done differently. And that was it. He did not explain it any further than that. It was a simple statement. I didn't dig into it. I didn't even know how. I don't know how I would have dug into that. That's something for you guys to figure out for yourselves. When you get the judge to that point where they say we do precedent, we interpret precedent different in Louisiana than other jurisdictions. And he said specifically jurisdictions because he didn't want to say other states. He didn't want to make this an us versus them He wanted to say jurisdictions because that's the safe word to use. Every state's got a different jurisdiction. Let's see. Okay. In comments, SMCG. Thank you. What are you contesting at the moment? I want to see the prosecutor in trouble for telling you to run. See, that's the thing. I'm contesting what Sachina, what Shanita is as written in the transcripts about Prosecutor Benjamin saying that I should go travel. I don't remember hearing that. All right, I would need to hear the transcripts to be more clear about what he said. But I mean, I would like to see the transcripts. It's not so much going directly to expecting the prosecutor to get in trouble. It's more a matter of hearing those transcripts. We got to hear those transcripts to be sure what Shanita has written is to be true. All right, she can swear to it, but she's called herself Joe Reporter. She swore that she wrote this to her best accuracy and all of that, and she calls herself Joe Reporter. So it doesn't look that accurate to me. And I don't remember things the way that she writes them. I think that, and there's inaudible. There's sections called inaudible where she just like didn't quite hear a word right or something. What happened there? I'd like to hear that inaudible part. How long does she take to try to listen to it to see if she gets it right? I mean, I don't think that I mean, with as much as she had to write, she probably didn't spend any time. If she didn't understand a word, she'd just skip over it and call it inaudible. When, if somebody else heard it, they would clearly know what the word was. So it's something that needs to be brought out for the public to hear and make for us to make our own decision. Well, I'm talking about for my court case. Out of the thousands and thousands of court cases out there, I'm focused on this. And yeah, nobody will ever hear those court recordings. Yeah, that's probably true with that. So I don't think the prosecutor's going to get in trouble. But yeah, what am I contesting at the moment? Yeah, it's all what my lawyer has written as part of his response to my prosecutor's reply, the response to the reply to the reply to the response, and it can only go with three. It can only have three writings. Yeah, it's the original writ, the reply to the writ, and then the response to that reply, and then it stops, and everything is submitted to the three judges. So but I'm questioning. I'm arguing about things that have already happened that I'm trying to take in. I'm trying to prepare myself for future issues with judges, and they cause a lot of problems. They've in a lot of places. Let's see. Don't you escape accountability? Okay, let's see. We must allow all officials our full respect and consideration, even though many of them are mental defective and crooks. Yeah, I've been saying for the past couple of months that there's police officers who are more reasonable than judges. Just you get that feel, you have an idea, and it's experience or instinct. I don't. It's you compare some cops on the street, and their and how they rationalize things to a judge who's never really spent time in the criminal court. Only and for Owsley's as an example with Owsley, he's been a divorce lawyer, he hasn't spent the time studying crime and criminality. He's been on the civil side of things, and then he takes on the crime. Um, and what kind of training does he have? Does he get? Does he have? Is he required to take a yearly test like the cops do? I mean, the cops have to refresh their training. Even the even the chief of police has to sit in on certain types of training, at the escalation of force or de-escalation. I mean, what kind of training does the judge sit in on? Is he required to have so many hours of training um, to do what he's doing? I'm not so confident that he does, especially by how he conducts himself and how his attitude is towards precedents. I mean, there should be some training for city judges. They're the lowest level. They're like they're lieutenants in the military, okay? You call them officers. There's officers in the military. The city judges are the lowest rank. They're butter bars. All right, they're second lieutenants, the lowest of the low, and then you rise up with ranks after that to what majors and colonels and generals. They go up in rank, but when you're in the lower ranks, there you can't be expected to be the city judges cannot be expected to be consistent with it's like especially with the type of the type of backgrounds, the varied backgrounds that a lot of them have. I mean, they're elected, but even in an elected field, there you'd think there should be some minimum standard of training involved to continue in that elected position. This is an elected position that's non-essential. Actually, pretty much all elected positions are non-essential, all right, in some capacity, um, depending on the size of the city and their priorities. Let's see what was it here. Our parish has the second highest percentage of adult misdemeanor cases dismissed. Second to okay. Yeah, I don't understand the statistics with what's being conducted in courts. They're taking in a lot of cases only once a month, so they get a huge crowd once a month at that city courthouse, and then they make their decisions on the fly. I just I made I made I took the approach differently uh, um, than what everybody else did. I don't I mean I don't know how it's done. I haven't studied city courts too much. I need a minimum amount of training for understanding. Let's see. There's a lot of different messages here. So your dad lost your property. Miller is buff. Yeah, Miller was a stronger of the three that who arrested me. He looks like he might weightlift, but there's a lot of natural strength that some people carry just by being young. They may not do much to maintain a large muscle mass. Domestic battery will be reduced to disorderly, so I don't have to send you to jail or make you do a program. Yeah, there's there's a real there's a clear agenda that's being conducted at this city court that I think it has a lot of influence from Judge Owsley's experience as a divorce lawyer. He probably took on a lot of cases where his clients were the abuser in the relationship, and so he may have more experience with the abusers and understanding them more, and fighting to give them as their attorney. He fought to give them lighter sentences, and he's using that experience on the bench to continue to give the domestic abusers lighter sentences. So there's like the habits that he learned early in his career. He's brought into he's brought into his position as judge too. You don't deal with cameras. You don't deal with First Amendment rights as a divorce lawyer. Like if spouses record each other doing doing weird things, unethical things. He probably approached cameras differently as a divorce lawyer, as compared to people exercising their First Amendment rights with cops. Let's see. Next time, hire a lawyer if you don't have much money in your bank account. I'm really blown. So hire a lawyer if you don't have any money? That's impossible. I'm really blown away they don't find it's a big deal you didn't have a lawyer. Yeah, they didn't. They were very casual. City courts are very casual about you not having a lawyer, because they look at it like it's just not getting a lawyer for failure to wear a seatbelt or stop at a stop sign. Do you really need a lawyer for a traffic violation? Most people don't get lawyers for that. They'll fight it themselves or just accept the fine, not really fight it. And I'm on the level of a writ. All right, it's my recourse after this is a writ, which a writ is for traffic court. I'm getting the same level of appeal that a traffic court defendant, somebody who was convicted in traffic court, would get. A writ. That's like being a pedestrian and jaywalking. It's like I'm being treated like a pedestrian who was found guilty of jaywalking, and my only way to dispute the guilty verdict is by writ. And I'm being treated on that. The level of writ, they have expanded. The writ has expanded from the bare minimum to jail time. People who face up to, as far as I know, face up to 6 months in jail. So it goes from jaywalking to some serious criminal matters that could put somebody in jail for 6 months. They've expanded that level of like a recourse or the appeal. The official appeal option doesn't start until I think until it's a felony. So the other states don't do that. The other states will allow an appeal to be written on much lower level, on a lower level than what Louisiana has set up. I'm lumped in with the same. Every writ that is coming into the Third Circuit of Court of Appeals right now, every writ that's coming in, I'm lumped into the pile of the same writs for all the other low-level criminal accusations. I'm in. They got a pile of writs and they got a pile of appeals. I'm in the pile of writs, and in that pile is traffic violations, or maybe maybe some civil cases, maybe some code violations, or disputes on the civil cases. There's a criminal. They put my criminal case in low level, low priority writs, and it's not something that just can be appealed. Let me see, because I want to appeal. I want to appeal a jail sentence. I don't want to writ a jail sentence. I want to appeal. Just hear that. Hear that. Hear me say that. I want to appeal my jail sentence. Doesn't that sound right? Instead of saying, I want to writ my jail sentence, it's stupid. It's just flat out stupid what the Louisiana courts have set up here. A writ is a form of written command in the name of a court or other authority to act or abstain from acting in some way. Yeah, abstain from acting. Abstain from acting like jailing? Abstain from jailing? I mean, it's we got a writ asking you to just stop your action, but I want to reverse that action through appeal. I'm appealing. I'm appealing my 30 days in jail sentence. I'm not writting. I appeal to you guys. I don't writ to you guys. I'm not asking you guys to stop, to ask them to stop. Just stop. I want this ended. I want this turned over. All right, writs aren't about turning over your court case. Writs are just to ask you to stop. Just stop doing it. That's why we had to get me out of jail before the 30 days. So then we could really make a case to ask them to stop. I get out before 30 days, so they say I face another 4 days, and we're asking them to stop the time in jail. All right, because that's what the Louisiana has set up as a part of their criminal case, the criminal laws in the writ. You can't just, and so that falls within their definition, but it's a very low standard, and it's a low standard for them to throw us in jail, and a high standard for us to dispute what they're doing. I want to make an appeal. I want to make a serious or urgent request, typically to the public. You got to go to the public in Louisiana. And when the courts tell you, and that when the Natchitoches City Court tells me that I shouldn't be making it public, that tells me I need to be making it more public. I need to be working harder to reach more people, to help people understand. I think there's this problem with the states. The state has given the city so much power to keep things secret and private, privatizing criminal trials, privatizing evidence, things that are normally public information is privatized. Let's see, in law, an appeal is applied to a higher court for a reversal of the decision of a lower court. I can't even, in Louisiana, they won't even allow me to ask for a reversal of the decision of the city court. I'm not in a position to ask to reverse that 30 days. All right? All I can do is ask them to stop. And that's why the timing, that's why Judge Ousley gave me 30 days, but not 60, not 90, not the full 6 months. Because he knew, he probably had an idea that in a longer sentence I would have gotten more help from the outside to make this writ. But it's such a low standard as a defendant in Louisiana. They have high standards to throw you in jail, and then low standards to throw you in jail. They got low standards to throw you in jail, and you got high standards to overcome that. Let's see. So yeah, it's a writ is about asking the sentence to be stopped, not to be reversed. It's such a stupid approach to crime, and that's what gets people locked up for long periods of time on low standards. And they got people doing hard labor. They even raise the punishment in Louisiana to hard labor for some reason. There's people who get arrested on low standards for arrest and conviction, and face high punishment up, looking at hard labor. So there's such a stretch, and it's gotten out of hand. But I'm asking for a writ to stop this, what they're doing. All right, abstain from acting. One's power to enforce a compliance. Yeah, I'm being forced to go to jail, and a writ is asking for that to be stopped. Stop the rest of the time in jail. All right, if I stayed the full 30 days, then the writ would really, I mean, it would come down to just a $411 fine, and that was it. That would be it. Stop that payment. But it's, for me now, it's stop that payment and stop the last 4 days in jail. All right. That's pretty much what I spent almost $20,000 on with my lawyer and all of that. Stop the $411. I paid $20,000 to ask them to stop that $411 fine and stop the last 4 days in jail. We've spent months and months now going through that channel, going to the Third Circuit appeals court to see what they have to say about that. We're in having to deal with the corruption that's happening in the city court. Let's see. Oh, okay. Yeah, I don't want to turn down Ace Jack's request here. Let's see. Here we go. All right. So it's such an open-ended deal. I mean, all I can do, I look at, we look at each court case with an open blank piece of paper. Even if you mention court cases, they don't care. They don't care about precedent. Precedent don't matter. And the best you can do to seek any recourse is by asking a higher court to make the city court stop what they're doing. And you pay almost $20,000 to ask the city court to just stop it. Stop what you're doing. All right, and then explain. Hopefully we get, well, my lawyer can explain why this should be stopped. My prosecutor explains why it shouldn't be stopped, and so now we need the the appeals court to get in, and actually they're being like the thin blue line. They're stepping in between to decide. We got two separate uh, like teams, and we're fighting, and now we need the referees to step in and try to bring some sense into this matter. They have to give they should give their insight. Hopefully, uh, it's just it'll be interesting. Do they want to continue the corruption and rationalize why the city court was right to do what they did? That'll be interesting. And yeah, it's a learning process. I'm trying to learn. I think Louisiana has got one of the lowest standards. The lowest standards for law enforcement, and the highest standards for defendants that I've ever seen. The city has higher standards for the community than they do themselves. Louisiana has set it up for every city to expect higher standards from their community, but lower standards for themselves. And it's a blank page going in. We don't care about what happened from the 1960s. That's pretty much precedent. Don't matter. Who cares about what happened in the early formation? If precedent don't matter, I mean, we're talking about if it's done differently. Well, okay. What you got to read through what Judge Owsley says for how it's done differently. Okay, he plays down some aspects of law and plays up other aspects of law. So you get some insights into what is done differently on how they look at precedent from other jurisdictions. Okay, you could write this down. This is stuff like, okay, recording in the courtroom. Precedent matters to Judge Owsley. He can't violate the Supreme Court's ruling on recording in the courtrooms. Okay, so with that, precedent matters to him. Okay, but when it comes to First Amendment rights outside of the courtroom, he asks, who records in a library? Who asks the cops for their names? But it's more, who records in a library? Okay, suddenly precedent don't matter about the First Amendment. So even within the First Amendment, it's like it's how it's applied within just the First Amendment. It's not across the board. We have freedom of speech and of the press. He steps away. He clearly steps away from precedent, making those statements about recording in a library, using that to sentence me. So he's picky and choosy with just the First Amendment alone. I mean, obviously, he doesn't care about precedents with the Fourth Amendment. They talk about Terry v. Ohio, and how that's that has been written in to the Louisiana statutes. So there sounds like there's respecting the Terry v. Ohio, and they say they don't feel that is unconstitutional what has been written into the Louisiana revised statutes, which in um, resisting an officer, they put right in the statute that you 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 resisted the officer by not saying your name. So that goes in a forward manner with how cops can are the cops are said to be allowed to work with this statute, uh, but there's preconditions for it. But those preconditions are ignored within the Fourth Amendment, within the Terry v. Ohio. We got the preconditions that give the cops this authority to demand our name or go to jail. I can demand your name, or you can I can demand your name with the threat of jail. But there's preconditions for that, and Judge Ousley only chooses to recognize the precedent, the precedent part where it says I can demand your name with the threat of you going to jail. I'm going to recognize that as judge. That sounds good. All right, I can use that. But those pesky preconditions of reasonable cause, probable cause, that's not so important. We don't care about precedent for that. Not in this city court. We'll just skip over that. We'll just make something up. Let's have the librarians imagine a scenario of me doing some horrible things in their minds, thinking that that's what's going to happen, and then testify to that. That'll be the preconditions. All right, crime is about to happening. It has already happened. That's we'll just make that a loose part of our recognizing the precedents of Terry v. Ohio. Even the mention of this court case is recognizing the precedents, but there's only parts of it. They can't take it as a whole. They can't take Terry v. Ohio in as a whole. They only want to choose the parts that are fun to play with, and I mean, because I only have the power to write a writ as a part of the punishment. I can only ask them to stop the punishment. They have such a low standard. They have such a they have just it's hard to describe. It's different. It's so different from other states. This lower standard to arrest and convict. This lower standard to arrest and convict helps them become more biased with precedent. You lower your standards to arrest and convict, then you can become even more spotty with precedent cases that most other courts more other courts will follow Terry v. Ohio more strictly than they will in the city courts of Natchitoches. They'll be more other courts would be more respectful of the whole opinion that came out of Terry v. Ohio. The reasonable cause, reasonable suspicion, actually have valid reasonable suspicion with proper evidence, not imagination. Okay, there's a very spotty precedence going on with the lower standard to arrest and convict in Louisiana. It's very difficult to work with, especially when they really weaken your defense. Why why even give us the option? Why even say we get a writ? Why not just say, hey, you can't appeal at all? Why not just say you can't appeal at all? Okay, you can't appeal anything until until you're facing a felony. All right, why even bother with a writ? I mean, they could make this a lot worse. But I mean, I have to see what the Third Circuit Court of Appeals has to say about this case. But I mean, it's like, by the way the city court in Natchitoches is acting, they seem so confident that that they get the whole bite of the apple, that the higher courts will just um, ignore this and think that there's nothing. If the lower courts don't recognize precedent or have a very spotty recognition of precedents, then why even bother trying to do anything? It's like It's like how powerless, how much power does the Third Circuit Court of Appeal actually have? You know, that's my question. Even if they chose my even if they decided in my favor, what can they do? It's only a writ. If they say, yeah, this is wrong, you know, you can't use imagination to convict people. So you know, we agree with the defendant. But what's the power? The power of the writ, the power of the appeal is something to brag about. The power of the writ is kind of it's quite embarrassing because it just tells them to stop. Okay, you've punished this guy more than enough. Okay, but no, they're just you can't you could say you a writ is saying you've punished this guy enough. An appeal is saying you've punished this guy more than enough. And you know, you win your appeal. Winning an appeal leads to lawsuits. Winning a writ it just says get this guy out of jail. Get this, you know, release this guy. That's it. A writ is just stop what you're doing, stop your action. Okay, but they won't go further than that. They'll just say stop your action, get him out of jail, stop fining, stop that $411 fine, and that's it. It's not you've made him spend too much time in jail. No, it's stop the action that's happening right now, not reverse the action. Take back what you did. Take back, you know, those 30 days. Compensate this man for what you've done to him. That's an appeal. Compensate this person for what you've done. We're setting the stage for this guy to get compensation. That's for an appeal. A writ is just stop what you're doing. That's enough. But we're not going to go further and say, hey, you know, this guy, you need to reverse everything, and this guy should be compensated for your tyranny. It's such a low standard for defendants in Louisiana, and I don't know why do the people live with that? I mean, Jesus, what's going on with in the minds of these people? They just live with that. I've talked to inmates who sit in jail for years and years, bragging about sitting in jail for 30 days. They could stand on their heads for 30 days in jail. Bragging, it's like a bragging right. And it sounds. I was asking about farms in the jail, and I thought that was interesting. Some guys said just 10 years ago they stopped Louisiana farms, and I mean, I'm talking about like raising cattle or growing gardens. They were doing that up to like 10 years ago. I mean, this is a 40-year-old guy who spent 15 years of his life in jail. Let's see, what do you call it? Louisiana farms? I know, a hundred years ago in other states they were raising cows and gardens. Louisiana farms, but jail. I think they're a little crazy. It's something I would need more of an opinion from. I need an opinion of not more than just from the inmates. Um, let's see. Set precedent. You can't set a precedent with a writ. What writ ever sets a precedent? But see, the thing is, what's interesting, in other states, this would be an appeal. So if this went beyond Louisiana Supreme Court, then suddenly it would go from writ to an appeal. They would be looking at this writ. Any jail sentence would be an appealable action in any other state. So in the federal court level, they would be looking at this as an appeal more than a writ. So, I mean, the Louisiana is working hard to keep the system in place by redefining jail terms, 6 month jail terms, as something that you can only write a writ about, and other states don't recognize that. They'd call it an appeal. And if it went higher beyond the Louisiana Supreme Court, then suddenly you'd have a discussion about how this is an appeal I'm making and not just a simple writ. I'm not just asking for a stop in the action. Stop that fine. A writ is usually for a fine. I think in other states, I'd have to look this up, but I mean, what is a writ? A writ is a written command in the name of a court or other legal authority to act or abstain from acting. Okay. There's nothing about jail in there, okay? I think Louisiana is so stupid, they don't even know what a writ means. Alright? Stop an action. A writ is a low-level recourse, and usually it'd be maybe for a traffic fine. You would go in front of an appeal board for a traffic court. You go through traffic court and then you appeal that to just a higher traffic court. A writ for a jail sentence? Okay, you can do that. I mean, it's saying commands to a legal authority to act. I'm not asking for that. I'm asking for them to abstain from acting. Okay, the abstain from acting is, maybe there's more definitions. What does writ mean legally? A writ is an order issued by a legal authority with administrative or judicial powers, typically a court. That's all they say about it. What are the 5 types of writs? Okay, there's a bunch Latin in there. Okay, why is writ important? What is writ in high court? Writ is a form of written commands in the name of the court. It directs you to act in a specific way. In the Indian legal system in India, you can file a draft or writ of petition under Article 226. Indian. Can I stop a high court writ? To attempt to completely stop the high court writ of control going ahead, you'll need to apply for a stay of execution. So I could turn around if they ruled in my favor. If my writ was ruled in favor, I could then turn around and then apply for a stay of execution on my own writ. If they said stop, if I got the high courts to the Third Circuit Court of Appeals to say, to agree to my writ saying that my jail, I shouldn't have to spend 4 more days in jail, If they say we agree, they approve that, then I can turn around and then apply for a stay of execution, pretty much asking for them to throw me back to continue with the 4 days in jail. That'd be a weird direction to take. This will allow you to have the High Court writ set aside. You were not made aware of the judgment. Officers have used incorrect methods to attempt to source payment from you. Yeah, the judge used the incorrect method to extort $411 from me. So yeah, a writ is just, yeah, it's not really it's not a fun word to use when you talk about this stuff, because it sounds so weak. It's like, I'm gonna appeal this case. I'm gonna appeal your sentence. No, you don't say it like that, because in any other states you can say that. But in Louisiana you say, I'm gonna writ this. I'm gonna writ this. That's so weak. They've weakened your defense. They've weakened it by language, by their actions. They've empowered their ability to arrest and convict. 454 misdemeanor cases, only 2 went to trial in front of a judge. Yeah, people have given up in that city. They take matters into their own hands on the streets instead. They don't trust the courts. They don't know how to deal with the courts. When they end up having to sit in front of the court, all they do is plead guilty, or take whatever offer that the prosecution has, and then they take their matters out onto the streets, firing guns almost every night, shooting each other, fighting each other, stealing from each other. They take a lot of revenge out on each other on the streets. They don't say, oh, let's wait until court. Let's settle this in court. The judge will be real honorable and fair. No, the judge will say that they're fair and honorable. That's all you get out of them. You won't actually get the action of fairness and honor, but they'll at least tell you that they're fair and whatever, trustworthy. Let's see. Yeah, taking my case to trial was unusual. Yep, that's something that I've been practicing. This is number 5, pretty much disputing the same type of thing. I would say there's 6 times really I got arrested over my ID, but that first time I actually did take a plea deal, and that was in Boise, Idaho, but really more specifically Meridian, Idaho. And the cops got on my YouTube channel and were trolling me. Those guys are no longer trolling me. It's every arrest brings different trolls, and they come and go. It's not like I bring in trolls and they stick around. They only stick around for their local issues. When I leave the area, when the case is done, they're done. So the trolls that are here today, if something else happens, they could be gone. If once this case is over, they could be gone. I mean, I've gone in what's almost 10 years. I don't know, maybe I had this channel 8 years. In the 8 years I've had this channel, I mean, I've had periods where there was pretty much no trolls. There was just silence from the trolls. There was nothing going on. Maybe I would just complain about something random, but I have no police interactions, no real issues in the court system, so there's no trolls. But when the cops want to arrest me and charge me with something, more trolls, enter my channel and have things to say. They're more trolls are more vocal when I have a court case going on. In between court cases, the trolls are more silent. When I just make a random video, even if it's just like a regular cop stop, if there's no criminal, if I have no active criminal cases, and it's just I just have a cop stop to post, there's really not a lot of troll activity. It's when I have an active case, I think that they're more active. Servants. Oh yeah, Ruben was back in Arizona pretty much. I think he followed my channel through up into New Mexico, but I think he was a little vocal when I was arrested in Hayden, Colorado. I think he might have still been talking, but I think he was losing interest because I was in Colorado, outside of his jurisdiction. Trolls. A lot of trolls are jurisdictional. That's why they call them bridge trolls, because they're very regional. They only care about the immediate area around them. If I'm outside of that jurisdiction of theirs, they lose interest. So, well, how long have I been talking here? I think I got most of my message across. Over an hour. Yeah, I think I'm gonna stop this. So, all right. Thanks for visiting, Lisa. I think I'm gonna and everybody else. Um, and have a good day.